Proceed. We have several people. We'd ask you to limit it to about 2 minutes and address the subject of the Board of Judicial Standards specifically in a testimony.
Absolutely. Good morning. Thank you for taking the time to hear me. My name is Brad Kramer. I'm a private citizen. I live in Stearns County. I've recently been involved in a child protection matter that's actually taking place in Candido High County, even though my children have never lived there. I'm a member of Justice for Parents and Children, which our mission is Justice for Parents and Children exists to be a voice and support for parents and children who have been harmed or exploited by an unjust and unaccountable legal, judicial, or government system. In my case, my parental rights have been terminated recently, and that decision came from Judge Donald Spilseth of the 8th Judicial District. And in several cases, he's broken several of the things that we've spoken about this morning here. Sleeping, not applying current Minnesota statutes, starting trial late, very late, oftentimes an hour or more late. Real briefly, my history is I have a degree in criminal justice. I'm currently employed. I have no criminal convictions or charges that have anything to do with child protection. I used to be a juvenile corrections officer, and I'm currently in school for my undergraduate degree in business management. In my case, the judge ignored several statutes, including Minnesota Statute 260C 178, Subdivision 3, Statute 260C .301, Subdivision 3, Paragraph A. I was never allowed visitation with my children for about the year that the case was going on, which is in defiance of the Minnesota statute. My father or my family has never been allowed visitation. In most cases, he's only seen his grandchildren one time in the past year. The judge did not enforce his own rulings in many situations. He did not force the county to file a termination of parental rights against my wife, who had made the frivolous claims even though she had her parental rights terminated in a previous case, which the law requires that CPS has to file a termination in that situation. The judge and
Mr. Kramer, if I may just add, did you file a complaint with the Board of Judicial Standards, and what was your
essentially, I'm fairly new to this process, and when I looked into it, when you realize that there really is nothing that, even if they investigate and find the judge did this, that they're not going to take meaningful action with the recourse that we have right now. And the ability for them to retaliate against somebody who may make a complaint against them. I mean, I'm still involved in the court proceedings, so if I take a course of action to file a complaint, and even at best case scenario they find that the judge has committed these acts, there really is no meaningful discipline for the judge by the standards that we have presently. So essentially, no, I have not filed this complaint with the process that we have right now, because I feel it's inadequate and wouldn't address what I have. So that really leads me to the Court of Appeals is my only recourse presently, and that will take up to a year to receive a decision. And I've already paid $25,000 in legal fees just for the appeal, plus possibly $10,000 just for the transcripts that are required for the appeal. So we're talking a very expensive and long process while my kids are in foster care, while they have family that would love to provide for them. Right now the taxpayers are providing for them when I would love to. I'm not even allowed to provide financially for my children when I want to. But instead the taxpayers are picking up the bill and my children are in foster care. 5 of my 7 children are. The judge and CPS ignored findings by Midwest Children's Resource Center. He actually slept through their testimony when these were expert psychologists who basically said that my children did not exhibit the symptoms that CPS claimed they did.
Mr. Kramer, we need to move along with our other testifiers. You want to summarize your testimony so we can complete this hearing today? We'd like to complete the hearing today, so if you could, summarize your testimony, and we'll get to the next testifier.
Okay, I'm almost done. Basically, he's in several situations broken these codes of conduct, and I have no recourse in the situation that we have now. Sleeping through testimony, starting court late, not following or applying Minnesota statutes in his rulings, not giving me visitation when the law demands that I have it. Things like that, that now my children, which in my packet that I've given you, there's pictures of my children with my family, with myself. They're not just a case, those are a family that's broken up from the situation that we have right now. And 3 separate foster homes, including the pictures of the foster family that you see there, when the children have family that loves them. And hasn't been allowed to even see them, even though, like my father, who's present, has no criminal history. He's a prominent business owner. He went to Brazil with Government Palenti a few years ago on a trade mission. Stellar person, but has not been allowed to see his own grandchildren because of the process that we have in place right now. And I understand that in our democracy and the judicial system, there's always going to be people who are not happy with the ruling that they receive. I understand that. I understand that the Court of Appeals is there to satisfy that, but on the other hand, when you have judges basically who are being watched over by members of their own fraternity, and it's a very close-knit group, where they're not going to take that action against each other, we need another board.
Mr. Kramer, I'm going to have to cut you off at this point and ask our next testifiers to come forward.
Good morning, my name is Leah Bankin. I am a resident of Carver County, and I live in Waconia, Minnesota. I am the individual that Dale Nathan spoke earlier about that is ordered to remove a blog from the internet. I received that order last August 5th, 2011. I also have not seen my infant and 2 children in 8 months with no reason whatsoever listed. There's quite a few statutes and laws that are being ignored. In my case, I did actually contact the Board of Judicial Standards. The first time I know I didn't receive a call back. The second time was in August last year when I was ordered to remove a blog from the internet. And I asked him a series of questions. I said, do you help out with U.S. Constitution being ignored? He said no. I said, okay, well, do you help out with statutes being ignored? He said no. And I said, okay, well, how about, a judge ruling bias? He said no, which is, I guess how it rules, and it goes anyway. And I did ask what they do. He said if the judge is my brother or my mother, that they would actually find me a different judge. I said, well, thank you. I said, should I file a complaint? He said, don't bother, we won't do anything. I have filed with the Court of Appeals, of course. I actually did file a writ of prohibition with the Minnesota Court of Appeals, which is pretty much an emergency appeal, trying to get contact to my infant and children. And the blog, I've been charged about $9,000 right now for this blog that is on the internet, and the blog is carvercountycorruption.wordpress.com that has court documents and criminal reports and facts on the case. And of course, they're not happy about that because what's coming out, what they're doing in these cases. There's quite a few in Carver County and around Minnesota, and so I've been ordered. It's about $9,000 docketing and judgment where they can garnish my wages and seize my bank accounts for this blog. So I filed a writ of prohibition, which was denied. So the appeal is actually accepted, and I will say on the appeals remedy, it takes about 9 months. My children are beyond devastated at this point. The baby doesn't even know she has a mother. She was taken at 11 weeks old, and there's no reason for it. And the Court of Appeals is going to take 9 months. And that is not an adequate remedy. On top of that, if the appeals court does find that there was wrong rulings or statutes that are being ignored, they actually give it back to Judge Richard Perkins, which did it in the first place. So the appeals court is not a proper remedy. So that's all I have to say. Thank you.
Hi, my name is Bonnie Roy, and I'm also a result of some negative influences from Carver County again. We're here to also support the bill that it has to look at the judicial process. Right now, we have, all of us in this room have spent an extravagant amount of money just to go through the court process.
Ms. Roy, I need just to remind you that we're here to talk about the Board of Judicial Standards today.
Thank you. In my case, I did send actually 3 letters to the Judicial Board. I do agree that on the letter it did state that the board has no legal authority to correct factual or legal mistakes in the court decision. For an example, you allege that Judge Canning did not consider certain evidence, nor did he not correct a fair ruling. The board's inability to consider these questions has nothing to do with whether these matters have been handled correctly or not. These questions are answered by the court system and not by the board. And again, I actually filed a complaint to the first judicial judge, Edward Lynch, and he basically said I need to go in front of a canning. And I went back there again, and it's basically like a hamster on a wheel. I get nowhere. The costs are astronomical. I basically submitted another letter. That one was in January. I submitted another letter in response March of 8th, and it basically says again that the board is limited to their power in regarding, even if they find allegations that are incorrect or correct against the law, which again, we're up against a wall. We have nowhere to go. Again, in another letter I received in September 27th, it says right on here again, the board has no legal authority to correct factual or legal mistakes. All of our cases have concrete evidence that the judges right here are committing and not abiding by the state statute of limitations in regards to child custody and child support. In regards to a guardian ad litem that specifically was on my case, these guardians are trained 20 hours. They are making court cases to these judges that are ripping families apart. This has to end. In regards to the court costs, anytime family law is stipulated, and it also included my complaint to the judicial board, it basically said, again, goes back to Judge Canning, I can't get nowhere. I tried to appeal it, I do modifications, and he basically says he stands as ruled. I have solid concrete documents that I presented to him at one point, 350 documents that showed fraud. You know what Judge Canning allowed? He said it's stricken from the court. Judges need to be held accountable for their actions. These actions of court officials need to stop ruining and devastating the lives of family. This is not about family law and justice. It's about tearing and devastating the lives, and parents are the end result of traumatic suffering of children in the family court, and I plead with you that this can change.
Thank you, Ms. Roy. And the next person to testify, please introduce yourself for the tape. And again, address your comments to the Board of Judicial Standards.
So my name is Edna Vasilowski. I'm an intellectual property attorney. My parents are actually immigrants. They came to the U.S. with nothing, and despite that, I managed to receive education at Stanford, Harvard, and Columbia. So I'm actually a big believer in America and the American system. But I've had some experiences in the court system that have, I guess, inspired me to come here. I had some prepared comments. I'm going to deviate. Instead, I want to address some comments that the speaker from the Board of Judicial Standards made. One comment that he made is that complainants have a zone of safety and that their identities aren't revealed. And so they can go to the board and not fear any backlash from the judge. I did not file a complaint with the Board of Judicial Standards because I had several phone calls with them where they emphatically stated that my identity, in fact, would be revealed. And I have their website here. Their website states under frequently asked questions, will my identity be revealed to the judge? Generally, yes. The board notifies judges about complaints unless there's an overriding reason to withhold this information. Will my complaint be made public? Usually, no. So the point of this statement is two things. One, all the Board of Judicial Standards does is provide a zone of safety for judges, because the complainant's identity is revealed to the judge. The complainant is then prevented from participating in any proceedings, so the confidentiality is to benefit the judge, doesn't allow the complainant. And then the confidentiality is also from the public. They're not allowed to know what's going on. This kind of goes to a second point, which had to do with elections. I actually thought about, what can I do to help improve the system? And I said, maybe I'll run for judge. And I looked into it, and part of the problem is they have these 6-year terms. In 6 years, they can cause a lot of damage. Secondly, because everything that happens in the board is confidential, the information isn't out there to the public, so they can't know. Lastly, there's an issue of what is their scope of authority, and then is their scope of authority actually effective? And it's fairly limited, so it doesn't address a lot of the harms we experience. Again, in the frequently asked questions, it says, what are some examples they can address? Improper courtroom demeanor, failing to promptly dispose of judicial business, conflict of interest, chemical abuse, engaging in improper election campaign activities. Those are not only tangential, but almost irrelevant to the real serious issues that we experience and they can't handle. And the last thing is the issue of, even if they had the proper scope of authority, or even if they did their job within their scope of authority, is it really effective? And the answer is often no, because the judge all they can do is offer a recommendation. The judge can then take that back into the court system and overturn it. And I believe the speaker gave an example of Judge Blakely accepted a $64,000 discount on his bill from his lawyer in order to refer clients to that lawyer. My understanding is the judicial board recommended that judge be dismissed, and the court system instead gave him a 6 months paid leave. So basically he got a paid vacation, 6 months. Who wouldn't take that? Plus a $64,000 discount on his bill for wrongdoing. So I know we have limited time. I won't say what I was going to say, but I have.
Thank you, Mr. Veselowski. And proceed, introduce yourself for the tape and provide your testimony again pertinent to the Board of Judicial Standards.
My name is Linnell Stroder, and I am just a lay person, meaning that I'm just a mother. And the reason why I'm here today in regards to the Judicial Responsibility Board is because I filed a complaint back in 2005. I was locked up in the Carver County Jail. My bail was set at $100,000 for a gross misdemeanor. And what is so pertinent about this is that it was in coalition to having lost my parental rights. Not only had I lost my parental rights, where a lot of the laws were violated, they flew out of state and picked up my children. I had a judge that was unbiased and prejudiced to where he filed the complaint, and out of that he's the same judge that terminated my rights. But during my appeal time, I sat in their jail with a $100,000 bail with blank search warrants, with the court hearings being bifurcated, and the only place that I could go to that I knew to go to was the Lawyers Responsibility Board, the Judicial Board, and to the State Public Defender's Office. And so if we don't have somebody to go into that says that not only is there that they would only look into personal misconduct, but what about the professional misconduct? What about the blatant disregard for the statutes and the laws? If I don't know the law, all I know is something's being done wrong. And so when I appeal to a board like the Responsibility Board, I would hope that they would at least investigate. To say the least, that I was, the charges were eventually dismissed, but they came at the dismissal once I made this complaint to the Responsibility Board. But the response that I got back to them was, well, it looks like it's been taken care of, so there's no need to investigate. But I believe had they continued to investigate that, they would have seen the intrinsic fraud that goes on within these court systems, and that right now today I have an 18-year-old who's been given back to me that's gone through 19 foster homes, 11 different group homes. That is just incomprehensible. What do I do with this child? But I believe that if the Responsibility Board, or there was somebody that would look in and at least investigate these things, that what we are coming here are not just frivolous complaints that say, oh, we lost, or they just ruled, or should they or could they rule this way, but that there's a blatant disregard for the statutes and laws that we the people are asking that the committee and that you as representatives would look into and uphold. And that's all that I have to say.
Thank you, Mr.
I have a quick question.
Representative Lay.
Thank you. What kind of gross misdemeanor are you gonna sit in jail on $100,000 bail on?
Exactly. It was a conspiracy to possess counterfeit checks, and there was no co-conspirators. There were blank search warrants. They were getting evidence from Ramsey County. They were bifurcating it. I had about 4 discovery hearings. The judge specifically would not allow me to speak. I ended up filing a complaint that I have here that went all the way that on my own, and all I carry is a GD. But yeah.
Okay, Ms. Just, so was this multiple counts then that you were?
No, it was 1 count. And it was given, and they filed it, it was from the child protection supervisor. So it was filed right after they took my child protection rights, and I went to appeal. And it was eventually dismissed.
Well, I'll ask offline about it, Mr. Chair. Gross misdemeanors are capped at $12,000 bail unless you have domestic assault, in which case it's $30,000.
It was
$100,000 would be a felony. But anyway, I'll ask offline, Mr. Chair.
All right. Thank you, Representative Lesh. Thank you, Ms. Schroeder. Do we have one more testifier yet? Yes. Okay, we have just 2 minutes left in our committee hearings.
Okay, my name is John McGrath. I'm a parent of 2 children. I've been involved in the family court for the last 5 years. I'm going to read to you briefly a short letter from my daughter. Mom and my brother kept saying, "You better come home." They told me to say, "I promise I'll come home tonight." I didn't say it because I was going to stay at Dad's. They kept intimidating me. Mom told my brother to say why he wanted me to stay. He said because he was lonely. Before I left, Mom said she'd burn all the stuff in my room if I don't come home. She laughed as if it was a joke. I'm afraid of what else my mom might do to me because she's been yelling and getting angry a lot. What we're dealing with here, and I appreciate the time that you've given us, is a travesty of our society that is destroying the lives of healthy children and healthy parents. This is an outrage, and it is because the judicial system in this state has absolutely no accountability whatsoever. It's the proverbial fox watching the hen house. I would beg you to take the time to look at all of these cases here, and what is going on in Carver County right now is an outrage. They are basically operating as an organized crime syndicate under the guise of the law. They are destroying 8 children that I know of. They're destroying their lives. They know exactly what they're doing, and it's all for the money. They have pools of money that they receive from state and federal government coffers that are open wide when they bring into the situation all kinds of conflict, and you need social workers and therapists and psychologists involved. It is an outrage. And you people are the ones who are responsible for changing the system to protect our children. And this happens in the family court system and in the criminal system because the victims are made powerless and they can keep it a secret.
Mr. McGrath?
Yes, sir.
We have one more testifier. Let me proceed with his testimony.
Thank you, Mr. Chairman. My name is Greg Worsel. I'm an attorney. I've practiced law for over 30 years. I'm going to make some recommendations about what I think needs to be done. First of all, I think a lot of the problems and a lot of the anger is caused by the fact that the Board on Judicial Standards, their hearings, their procedures are not open to the public. There's no transparency. I myself have filed complaints with the board. You get a letter back 6 months later that says we're not proceeding, and you don't know that they've ever actually listened to what you had to say. You don't know what the judge said in response, and you weren't given a chance to respond to what the judge said. And it seemed to me to be a total waste of time, and I talked to other lawyers, and they are of the similar opinion. So my first suggestion is these things need to be made open to the public. There needs to be far more transparency. Secondly, the board needs to look at judges' decisions. They take a policy that they will not look at a decision that's appealable, but I'm going to tell you, we have judges out there who are refusing to follow the law. They know they're refusing to follow the law. I've had judges say they're refusing to follow the law. Now, this isn't entirely the problem of the board. It's part of the process, the problem with the process. And I'll give you an example, because the process ends with the Minnesota Supreme Court, and that is part of the problem. In Canby, Ohio County, we had a judge who refused to follow state law on repeat DWIs. The law says that either the person is supposed to post $10,000 bail or be put on an alcohol sensor. The judge would refuse to do both. The county attorney objected. The issue ended up finally in front of the Minnesota Supreme Court, and instead of telling the judge to follow the law, the court threatened the county attorney that if he continued to file complaints and remove the judge, that attorney would lose his license. That's part of the problem, is that we have this process ends with the state Supreme Court. My suggestion is, right now, the rules should be created, the rules that the judges follow should be created by the legislature. Right now, they've been created by your Minnesota Supreme Court. They only did that pursuant to a statute you created that actually established the Board on Judicial Standards. My suggestion is that you remove that final appeal to the Minnesota Supreme Court. Again, there was testimony here today that the board would have removed Judge Blakely from office, and the board would have removed Judge Karasoff from office. But the Minnesota Supreme Court is putting one judge in charge of other judges only remove them from office for a short period of time. I think a judge who lies, which is what was said of Judge Karasoff, should be removed from office. I think if you did not live in your district, you would be removed from office. Finally, the suggestion has been made that elections are a possible solution, and I fully agree, but you have to have elections that work. These elections we have in our state do not work. The primary problem is that the word incumbent makes it almost impossible for anybody, which is found on the ballot only in judicial elections, makes it almost impossible for anybody to successfully defeat an incumbent. In the last 50 years, no incumbent judge on the Minnesota Supreme Court has been defeated in an election, and no incumbent judge on the Minnesota Court of Appeals has ever been defeated in an election in the entire existence of the court. The election system is not working. Give us a system where we can remove judges, where we can hold them accountable, and you will not have angry people in your presence anymore. Thank you.
Thank you, Mr. Wurstel, for your testimony. Our time for this committee has
Mr. Chair,
expired.
I've waited 20 years to have a shot at this. I would like to speak.
Sir, just let me consult with my vice chair and my DFL. Sir, we will concede. We will give you 2 minutes.
Okay, first, let me, again,
Please identify yourself for the
my name's Don Mashik. I live in Monticello, Minnesota. I'm going to first try to paraphrase some thoughts, and I don't know who to directly attribute it to, whether it's founding fathers, Cato, or Aristotle. But basically, there's a concept called first principles. And one of the first principles that the founders had in founding this country was that men by nature have free will, and men are not virtuous. And therefore, we must construct government to protect all men from each other. It disappoints me that this committee allowed somebody to say, why is there a camera here? That is the very transparency we're talking about. On the specific point of the Board of Judicial Standards, it is a joke. It is an absolute joke. And one of the things I don't think anybody's brought up is the standards of evidence. You have the preponderance of evidence, you have beyond a reasonable doubt, and then in the Board of Judicial Standards, you've got clear and convincing. So I can't think of anything more difficult than proving that a bunch of lawyers and judges are corrupt, whose profession it is to play with words. Clear and convincing. By the time you realize you've been screwed by your own attorney or the judge, you're not allowed to record anything, so where's your clear and convincing? Transcripts get altered all the time. This is ridiculous. And just to give you an example of what happens when you folks aren't transparent and you folks don't hold people accountable, I want to refer you to Volkmer, Fabian versus Volkmer, A10-1205. Your own district court, your own appellate court, your own Supreme Court ruled that lawyers do not have to treat their clients with integrity. They ruled that the lawyers' code of professional conduct is not an implied covenant of a contract between a citizen and a Minnesota lawyer. And you folks have done nothing about that. How do you let that go? And that's not something you can appeal to the Board of Judicial Standards. I spent $20,000 on an attorney, never gotten 2 years, no deposition, discovery on the very last day, and didn't get my to amend the complaint. And they want to rule that I agree, it was my fault. $20,000. And you let them rule. Where are you people not outraged that they ruled that lawyers don't have to treat citizens with integrity?
Thank you, Mr. Martin, for your testimony. Having expired our committee time, this committee is adjourned. Next committee hearing will be